This is Michael Popok, Legal AF. There's a reason Jack Smith is the special counsel, because he comes up with brilliant ideas and brilliant applications of criminal law to fit this unique set of criminality and facts by Donald Trump and the co-conspirators. I mean, he sat around and he figured out with his prosecutors what is the best set of crimes. And he even latched onto one that we on Legal AF didn't even think about, but we should have, because it's not only a page out of the DOJ manual, it's a page right from the federal election fraud fact sheet. It says, take a look, if you're a prosecutor, at whether 18 U.S. Code 241, a 241 charge fits the bill. And Jack Smith and his team decided that it did. And I'm going to talk about it here on this hot take because it's novel, it's brilliant, it's genius. It's a statute that's elastic that will wrap around all of the unique facts, Donald Trump and the co-conspirators, and wrap them up and tie them up in one bundle to be presented ultimately to a grand jury and then, more importantly, at a trial for conviction. 18 U.S.C. 241, a voter fraud and voter intimidation statute, which was passed in our history during Reconstruction after the Civil War to protect people like the freed slaves, the freed African-American citizens who now have the right to vote. But there were groups in America like the KKK and others that did not want them to exercise that constitutional right to vote, so they interfered with it. They interfered with it in many different ways. Intimidation to stop them from voting, to stop their votes cast from being counted fairly, and other conspiracies to injure the American citizens who were trying to exercise their constitutional right in exercising that right. Now, how do you apply that to Donald Trump and fake electors and the intimidation that Donald Trump tried to exert on election officials, state officials, legislators, and the like? I'm going to talk about it here on this hot take. Let's start with what is 18 U.S.C. 241. You have to have, in order for that to fit the crime, 2 or more people, we know we have that, who conspire to injure or oppress, threaten or intimidate. We have all of that here, and I'll break it down on the hot take. A person in their free exercise of a right or privilege that's guaranteed to them by the U.S. Constitution. And that is a crime that someone who's convicted of it can be imprisoned up to 10 years. Now, let's talk about how that statute has been used in our past based on our body of jurisprudence and law. It's arisen in certain cases like this. Think about it, and then I'll apply it to the fake electors, the intimidation of election officials, election workers, the lawsuits that were filed by Donald Trump, Jenna Ellis, Rudy Giuliani, Sidney Powell, and the like. The cases that interpret 18 U.S.C. 241, because we are a justice system that's based on precedent, on prior rulings. It arose in areas like ballot stuffing, which is exactly what it sounds like. You take fake ballots, you stuff them into a ballot box or the electronic equivalent of it. False voters, false tabulating of votes, right? And other intimidation. The two main cases that are out there that talk about these things, one is a Sixth Circuit case, and the other one's a U.S. Supreme Court case. In Pritchard versus the United States in 1950, 254 fake ballots in 11 precincts in Kentucky were shoved into a ballot box to try to change the outcome of the election. And the judge there, in an oft-cited case, meaning frequently used as precedent to support other cases, said that forged ballots dilute the influence of honest voters. Hold that thought in your head when I talk about the fake electors and what that does to your vote, my vote, and everybody else's vote. Because what it does is it corrupts the vote, because people voted for Joe Biden in the battleground states, and these fake elector certificates that were being submitted and led by Donald Trump and his henchmen to submit to the National Archive, to bring to Congress and hand to Mike Pence, hoping that Mike Pence would recognize the validity of these fake certificates, that disenfranchises you, me, and really everybody else, Trump voter, Biden voter alike, because it's not an accurate and honest tabulation of what happened. It's a fake certificate. It's the ultimate fake vote that's being stuffed into a ballot box because it's an electoral vote. And it's the electoral college that votes and elects our president. Yes, our popular vote is important and our state-by-state vote is important, but it's only important because it leads to electoral votes and electoral certifications. There's no case law on this because no president's ever tried to steal the election at the electoral certificate level. If they've done it, it's done by stuffing ballot boxes at the precinct level, at the popular vote level. So that case from 1950, the Pritchard versus United States case, though, stands for the proposition that you, me, and everybody else in this republic has the right to have their vote honestly counted. And then we move forward to the city the Anderson case, the Anderson versus United States case, which was written by the late, great Thurgood Marshall. And he, citing back to the Pritchard case from the Sixth Circuit, said the following, and this is what resonated, obviously, with Jack Smith. Quote, every voter has a right under the Constitution to have his or her vote fairly counted without it being distorted by fraudulently cast votes. So now let's apply that to the facts that we know that have already been developed. Facts that everybody that watches Legal AF on the MeidasTouch Network know, who watch our hot takes here on the MeidasTouch Network know. Even if you've heard some disinformation campaign out there by Donald Trump's lawyers saying, we're worried there may be other witnesses or other documents that we don't know about because we're surprised by the 241 charge. You shouldn't be. We know the law. I mean, I could sit and do a whole hot take for an hour listing every witness that we know have gone into the grand jury, including at least 6 former lawyers for Donald Trump who are now testifying against him, his former chief of staff, Mark Meadows, testifying against him, Rudy Giuliani testifying against him, the fake electors testifying against him, the person that was responsible on election day to go collect, and after that collect and implement the fake elector scheme are all cooperating with Jack Smith. And we know the subpoenas that have gone out to the Secretary of States in every battleground state to get the contact and communication between Donald Trump and those officials, whether they be in the state house, the Speaker of the House, Republican Party of that state, election officials, or the like. So the only thing I can conclude is that comment that was released by Donald Trump's lawyers, apparently, like, oh, we don't know why he's being indicted, is really just a misinformation campaign to sort of, try to blow some smoke and pee on Jack Smith's case and say, well, we don't get it. We don't see it. Well, go look at 18 U.S.C. Section 241, which I'm talking about on this hot take, and you'll figure out how that's being used. Let me explain it here. You take that statute, right? You take that statute that requires 2 or more people to conspire to injure, or oppress, threaten, or intimidate. It's an or. It's not and. So injury to voters is enough. Also, threatening and intimidating is enough. So let's break it down. The conspiring to injure would be the fraud in the forged certificates of the electors in the battleground states, in which, like, for instance, in Michigan, 18 Republican operatives and high-level Republican officials in Michigan and the National Party met in a basement secretly, took an oath to keep it secret, signed their name as if they were, and certified under penalty of perjury that they were the duly constituted and duly authorized electors of the state of Michigan voting for Donald Trump. Like that. And that went on not in state capitals, but near state capitals and in basements all around the battleground states with people just like those 18 in a coordinated effort led by Donald Trump and the Trump campaign and the Trump White House. All right. So you have that going on. Those fake certificates are the equivalent of stuffed ballots, fake ballots, false tabulation. And that is an 18 U.S.C. 241, a 241 violation. But that's not all. Donald Trump is on record and on recordings in Georgia, in Arizona, in Michigan, and other places, picking up the phone himself and calling to try to intimidate secretaries of state, speakers of the House, election officials to flip votes from Biden to Trump. The vote tabulation was already done in all of those states. Donald Trump lost all of those battleground states by 5,000, 10,000, 15,000 or more votes. So many votes that it would overcome any fraud in the election. Any person double voting, bringing their dead mother-in-law's ballot with them, voting in the wrong precinct. This was so many votes that it would overcome, just kind of normal stuff that happens in an election. Yet Donald Trump called to try to flip votes. And it's that flipping the votes with baseless allegations of voter fraud, of fraud in the election, that is a 241 violation. And we've got Donald Trump on recording in Georgia, in Arizona, at least him, sometimes with Rudy Giuliani, and sometimes with Mark Meadows, and sometimes just by himself. And those witnesses have already testified before the grand jury or are cooperating with Jack Smith. The lawsuits that were used, right, as the tip of the spear of this crazy scheme to topple democracy, these 70 lawsuits that were filed in which they went 0-70, led by Team Crazy Captain Rudy Giuliani, Sidney Powell, Jenna Ellis, and then they grab local lawyers in all the jurisdictions who were willing to take an oath to the MAGA cult leader and file these lawsuits, and lost every one of them, state and federal. Every one of them, including ones that went up to the U.S. Supreme Court. But those lawsuits, the act of using those lawsuits can be seen as a threat or intimidation in the free exercise of somebody's right to vote, right? So that's another element of vote flipping. The attacks on election officials. Rudy Giuliani is in the middle of a defamation case that he's going to lose in the District of Columbia before Judge Beryl Howell, because he went after, on behalf of Donald Trump, who did it too, went after these two poor election workers in Fulton County, Georgia, Ruby Freeman and her daughter, Shay Moss, and said they are committing voter fraud. And there's video evidence of it, when all they were doing was properly counting votes, tabulating them, taking votes that were already counted, putting them back down in a locked cabinet, a locked suitcase underneath the table, which is how you do vote counting. And if any of these idiots had ever been in a tabulation room or watched it like I have, they would know that this is proper process. But they don't understand the schematic of proper process for vote counting on an election day, so they have no idea, right? Because Donald Trump generally mail-in ballot, he voted by mail-in ballot, the thing he very attacks. Okay, let's put that aside for a minute. Going after Shay Moss and Ruby Freeman, and they're not the only ones. There's others all around the country who are suing places like Fox News, Donald Trump and others, for being falsely accused of voter fraud. But that was an intimidation tactic. It failed, but that was an intimidation tactic that is a 241 crime. A Section 241 crime, to intimidate election officials, right? Intimidate people, and by extension, intimidate voters, right? Who voted, right? But, have doubts about their vote. When you vote, you're entitled, as the Supreme Court said, to an honest count, to not have to worry that your ballot is going to be disenfranchised or invalidated in some way by somebody's conspiracy. And that is the beauty of Section 241. So let's run it down. The conspiracy to injure, threaten, or intimidate somebody in the exercise of their constitutional right, in this case to vote, applied to Donald Trump and all the conspirators, right? We have the fake elector certificate. We have the attacks on election officials and vote counters at every level within a state, from the Secretary of State down to the lowly poll worker. You've got the lawsuits that were brought by Donald Trump's team, led by Rudy Giuliani, Sidney Powell, Jenna Ellis, and others, to try to flip votes. You've got the phone calls from Donald Trump and others, including Rudy Giuliani and Mark Meadows, to senior election officials at the Secretary of State level, at the House level of each state, trying to flip votes, to try to take, in Georgia, for instance, 11,758 properly cast ballots in favor of Joe Biden and flip them and make them go away. disenfranchising, invalidating, and violating your, mine, and everybody else's right to an honest count in the vote. And that's the beauty of Jack Smith, because he's thinking in 5-dimensional chess, while even legal and political pundits like us are behind. And now we're catching up with hot takes just like this one. That's what the target letter said. The target letter and the indictment are two different things. In fact, prosecutors don't have to use target letters at all. So a lot of people are running to their microphones and saying, oh, I didn't get a target letter. That's a good, yay. Rudy Giuliani said it. And John Eastman, who's the creator, the constitutional law professor, the creator of the fake elector scandal. Yay, I didn't get one. Hey, newsflash, you don't need one. The Department of Justice, as part of its DOJ manual, doesn't have to give you a target letter. In fact, inviting defendants who they're going to prosecute to the grand jury and their own grand jury is very unusual. They did it for Donald Trump because, he's the former president, and it's just, they know they're going to indict him anyway. They might as well give him the target letter. But others don't have to get the target letter. So not getting one is not a badge of honor, and it's not immunity from prosecution. So we know from the target letter, there's at least 3 counts in there that are going to be in the indictment sought by Jack Smith later this week. The one I'm talking about here on the hot take is Section 241, the one that came out of the blue that we weren't expecting, but maybe the most powerful set of laws to wrap elastically around the conspirators and the acts that he has in his arsenal. The indictment can be broader than that. There is no law that says, wait a minute, the target letter said 3 counts, but you brought 12 counts against me. That's not an attack. That's not prosecutorial misconduct. The target letter just puts you on notice that you're a criminal target. And then you can do whatever you want to do after that. I don't know what the indictment's going to look like. You'll see it when it's issued. You'll see it when it's returned by the grand jury. And we'll see it too. And when that happens, and we see a much broader indictment than the target letter, we expect to see 241 in there, but it'll be in there with even counts we haven't even contemplated yet, and co-conspirators, both named, meaning indicted, and unindicted in there. It's not going to be Donald Trump alone. It's going to be Donald Trump with at least 2 or 3 other people, okay? And if they're listed currently in that first indictment, because there'll be more than one, if they're listed in that first indictment as an unindicted co-conspirator number whatever, they could easily flip to becoming a indicted co-conspirator in the next indictment if they are not already cooperating and have an immunity agreement. And we'll follow that too. I do hot takes and analysis just like this one, only on the MeidasTouch network. You can find me if you want to go to the MeidasTouch YouTube channel, like you're already on. Go over, free subscribe to the YouTube channel, slide over to playlists, and you can find all my content there as under Michael Popok. I also co-anchor a leading political and legal podcast called Legal AF. It's on the MeidasTouch network, but then you knew that, on Wednesdays and Saturdays. And you can watch the video, and then you can pick up the audio of the podcast, every platform that you get your podcast from under Legal AF. You can follow me on social media. I'm Michael Popok. You can follow me everywhere on social media, including Threads now, at MS Popok. This is Michael Popok, Legal AF reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram, at MeidasTouch, to keep up with the most important news of the day. What are you waiting for? Follow us now.